Okay, and good morning, everyone, and welcome to Wednesday morning's breakfast seminar. Today, we are looking at recovery of loss, expense, and global claims, and this will be presented by Richard Silver, Senior Partner. As always, happy to answer any questions that you have, and if you can utilise either the Q&A or chat tools in the bottom toolbar there, and Richard will endeavour to answer as many of these as possible at the end. I will hand over to Richard so that we can get this started. Richard, over to you.
Thank you, Julie. Good morning to you all. My background is in construction. I am an ex-chief surveyor and construction director. And for those of you who have listened to some of my previous seminars, you will be aware that one of my boasts, maybe not boast is the right word, but one of the facts is that when I worked in construction, not one of the projects I was involved in actually finished on time. And as a consequence of that, quite obviously, it was not our fault. And we claimed both extensions of time and loss and expense with some success, but also with some failures, and did not always recover what we thought was our rightful entitlement. Since moving into the legal field, I am an expert witness in programming and planning and quantity surveying, so have provided expert testimony in regards to claims. I've also represented parties in adjudications, arbitration, and in litigation where there have either been claims for loss and expense or where we're seeking to defend those claims. I'm also a panel adjudicator, including on the RICS, and quite often matters that come before me concern loss and expense, and indeed I have a number before me at the moment. And quite often when we're looking at these claims, arguments of whether or not they are global claims and whether such claims are able to be advanced are matters or issues that I have to address. And that's what I hope to cover for you today. The starting point is, and again, if you listen to my seminars, it always depends upon the contract. So if you're going to make a claim for loss, expense, delay, the first thing you must do is to consider the relevant terms of the contract. And most standard forms provide for the recovery of loss and expense in one format or another. There are considerable benefits of having the provision for the recovery of loss and expense in the contract, because it means whoever is the contract administrator is given the authority to deal with it. It also sets down parameters of how that loss and expense is to be approached in regards to both its notification and its assessment. So there's a set down procedure that both parties should be aware of and will be guided on how to follow it to deal with the particular issue. So by way of example, JCT, we have the provisions for extension of time and then separated one for loss and expense. By contrast, under the NEC, we have them amalgamated into compensation events, which would include any costs associated with a breach having been caused by the employing party. However, whilst we can claim under the contract, unless the contract says otherwise, we can also claim under the common law. Now, under the JCT form expressly provides that the common law rights of the parties are retained. That, however, is not the case under the NEC. Under the NEC, the contractor's entitlement is only for the recovery of compensation events. So should they fail to comply with the notice requirements under the NEC, they cannot fall back as an alternative claim under common law. Under the JCT, one could. Now, when we're talking about claims for delay, disruption, or other claims, they can effectively take three forms. Now, quite clearly, under most main contracts, where the employer is arguing that the contractor has been delayed in completing the works, the general claim is for liquidated damages. And as we'll see in a moment, this must be a genuine and reasonable pre-estimate of the employer's loss. So it's a simple situation. The contract says you shall complete by this date. It then says, should you fail to complete, you shall pay me £100 per week or part thereof. It's then a matter of fact, did they complete late? If so, you times the amount of period of delay by the amount per week, a simple calculation. There is, as we'll identify, considerable benefit in having liquidated damages, but because of this, they are always construed contra preferentum, against the party seeking to rely upon it. So if it can be shown that there's any reason of uncertainty, then the liquidated damages may well fail. And for those of you who attended my last month's course, when I dealt with extensions of time, I addressed that particular point. Now, whilst main contracts provide for liquidated damages, most subcontracts provide for general damages. I should also add, I have a number of cases that I'm dealing with at the moment where employers are claiming general damages for defects, particularly in regards to, wait for it, cladding. And this, in dealing with these claims for cladding and damages, much of which I'll cover in a moment, will equally apply. But most subcontracts provide for general damages. They provide for damages in regards to the period of prolongation clause. And then quite often, the contractor will also seek the liquidated damages that it's incurred up the line from the employer and will pass it down. And the simple rule on general damages is to put you back in the position you would have been but for the breach. And it is whatever it is. It is the figure that you can substantiate, which we'll address in a moment. Now, I put this third point here just to particularly deal with the NEC. The NEC is a very unusual contract. It provides for compensation events, and in regards to the compensation events, the issue of quotations. Now, those quotations include for any period of delay. If we're doing quotations in advance, they can't be the actual cost. And the NEC is actually providing for value of the delay cost, not actual cost, because it is a projected amount. And what's more, if you're following the standard form, it's based upon the schedule of cost components, which is again a value based. There is no reason why you can't have in the contract effectively a value base. It's not really dissimilar to liquidated damages. It's setting down a formula to assess the loss at the beginning. We're now going to look at these different alternatives. Now, as I've mentioned, with regards to liquidated damages, it is a stipulated sum. Now, often the question comes to me is, well, you know, the employer didn't incur any loss. Can they still recover it? Well, the simple rule is the parties have agreed a set sum, and provided that sum was a genuine and reasonable pre-estimate, it's recoverable. So let's give two examples. The contractor has entered into a contract with the employer where there is damages of £1,000 per week. Contract is delayed, but the employer doesn't incur any loss. The employer can still claim that £1,000. The fact they haven't incurred a cost is irrelevant. Because if we look at a different situation, what happens if the employer lost £2,000? They can't claim the £2,000. They've agreed £1,000, and that is the amount that is recoverable. So, provided the clause is a genuine and reasonable pre-estimate, there is no obligation to prove anything, and they can claim it whether they've incurred the same amount or less. As a general principle, it is meant to reflect what was the forecast loss by the party were there delay. What it's not meant to be is a threat seeking to impose upon the other party that if you don't finish, you're going to have to pay me £80 million. It's not a threat. It is meant to be a forecast of what your loss is. However, the case law in recent years has slightly reviewed that situation and have recognised that there is importance in the employer ensuring that the contracts they enter into are followed. And therefore, they have shown in certain circumstances that notwithstanding the loss may be slightly greater than what could have foreseen, it is nevertheless recoverable. When having liquidated damages, however, the general advice, and I've got a few points here, is make sure that the amount that you've stipulated can look commercially justifiable. You know, if you're building a house and it's an average house, you're going to have great difficulty proving £10,000 per day. So it should look roughly reasonable, and that you can look at it and say, yeah, I think that makes common sense. Equally, where you've got numbers of sections, there's likely to be a different loss depending upon which section finishes late. You shouldn't have the same amount of damages for each section. Where you're saying that someone is to pay a particular sum of £500 by this week, you shouldn't be saying that if you fail to do so, you pay me £1,000. Quite clearly, it's going to be difficult to substantiate that. Now, I'm aware with local authorities, quite often they have liquidated damages in their contract and they use a formula. Make sure you ideally keep that formula or how you've calculated damages to prove that what you put down was a genuine and reasonable pre-estimate. However, I do emphasize it is not for the employing party to prove that their damages were reasonable. It is upon the other party to prove that they were unreasonable. The final point, although it won't always succeed, is to have an express provision in the contract that says that both parties agree that the amount stipulated as liquidated damages was a genuine and reasonable pre-estimate. Okay, what we're now going to look at is general damages. And the big difference with general damages, it is not a pre-agreed sum. And this places a far greater burden on the party seeking to recover the damages. And we're looking at two things. And it is the first one quite often that is the most difficult. And that is causation. And what we're looking for is a party to prove that the other party is responsible for the loss. And of those of you who have been on contracts, you will often know that it's not as simple as that. Yes, we've got a delay on site that is caused by late instructions, but we've also got problems where the contractor is responsible. There isn't one critical path or one path. There's often loads of different paths. And there is often arguments of concurrency and which is the critical delay and otherwise. But what we're trying to show is that the loss that we're seeking is the loss caused by the other party. Or put it another way, that but for the other party's failure, this loss would not have been incurred. So the first one is causation. You caused me this to happen. And then it's a quantification. What was the loss as a result of those problems? And there must be this link. And that is the difficult thing that contractors quite often struggle to meet. Now we're going to go back some time to 1854 and Hadley versus Baxendale. And this is the most important case that deals with the issue of causation. And what they've said is that in causation, there is in effect what they refer to as two limbs. In other words, there is two ways you can seek to recover losses. The first one is the easy one. Those that may fairly and reasonably be considered arising naturally from the breach. You're building me a house. You finish 1 week late. I can't live in that house. I now need to live in another house. It's obvious. You're employed me to carry out certain works to complete by the completion date. You issued me instructions. I'm now delayed on site for a longer period. I'm going to be prolonged. I'm now going to have to retain my resources on site for longer periods. It's obvious. You were aware of it. You know, I needed to have a site agent on site. It naturally flows from the event. However, we have the second limb, which is not that naturally arise, but that was in the contemplation of the parties at the time the contract was entered into. And I do emphasize this. It is at the time the contract was entered into. Now, the reason I really emphasize this is that quite often the date you entered into the contract can be considerably after the date you actually started the works. How often are contracts signed 6 months after the job started? The works originally were carried out under a letter of intent, but 6 months later, the contract is finally signed. What we're going to look at is the date of signature on that contract. And I've even seen contracts that were entered into after the works were complete. But it is at this date that we are looking. And at that date, we need to work out what could both parties foresee as potential losses. And I give you one easy example. Liquidated damages under the main contract. A subcontractor is unaware that there are liquidated damages under the main contract. They are unaware of the amount that is stipulated in that contract. So if they're not informed of this amount at the time of the subcontract is entered into, they would not be recoverable by the main contractor. This is why when most standard subcontracts are used, they include details of the main contract and what the liquidated damages stipulated under the main contract are, because without that information, they are not recoverable. Okay, as I said earlier, I was a quantity surveyor on site, worked with loads of projects, did loads of claims for loss and expense. And, you know, albeit it was a long time ago, it was my view at that time that loss and expense was additional profit. We were trying to make loads of money. We ran loads of claims for overheads and profit, lost opportunity, all these different things. And, you know, sometimes we were successful. But the basic principle is that damages are to put you back in the position you would have been but for the breach. They are not seeking to get you more money than you would have otherwise have obtained had the job gone to plan. Now, I am aware of some questions that have been put by certain people that address this particular point, and Julie, at the end of this lecture, will raise those questions and I'll answer them. But I really want to emphasize this. The intention of damages is to put you back in the position you would have been, but for the other party's breach. Now, that's the issue that then arises with global claims. Because quite often the argument is the global claim is not putting you back in the position you would have been, it's actually giving you a secret profit. And that is the criticism of global claims. What it seeks to do, it is argued, is reverse the burden of proof. Rather than the contractor proving their loss, it's now down to the employer to reverse, or is to put their case why the amount is not recoverable. Now, let me just tell you what a single rolled up claim or a global claim is. Something like this. I have been paid £1 million. It cost me 1.5. Please pay me £500,000. It was caused by your failure. Loads of reasons, but there are too many of them. But basically, £500,000. That's a global claim. Now, loads of people put them in loads of different formats, and there are different ways of doing them. But the question is can you, from what has been provided, determine what loss relates to what failure? Now, if there's been only one failure, that's much easier. Now, there was one delay. It was caused by deferred access, and my claim associated with deferred access is £10,000. That's not a global claim. But if there are 12 separate events, and then I claim 12 weeks of prolongation costs with not putting the amounts down to the events, then that is likely to be a global claim. And the question is can you do it? And are you entitled to do it? And one of the questions I saw by one of the delegates beforehand is Walter Lilly the case still good law? And the answer is yes, it is. So when people are dealing with global claims, the key case is this one, Walter Lilly. It is well worthwhile reading the judgment, not if for any other reason, but to see some of the correspondence sent by Mr. McKay. Mr. McKay was an extremely wealthy person, and he wrote some correspondence to the tune of whatever happens, I've got to have loads of money and you're not. So do read it. It is quite amusing. Now, the starting point is that in Walter Lilly, the court actually decided that the claim advanced by Walter Lilly was not a global claim, despite those being the allegations put against it. And what the court said was that in regards to the claim advanced by the contractor, it did deal with, in full particulars, what was the delay and what had caused that delay. And then in seeking the additional extended prelims and profit, those were allocated against the delays. And it was further the case that the amounts that had been claimed, there had been extensions of time granted for the events claimed. And therefore, causation had been dealt with. Lilly's had identified why they'd been delayed. They had been awarded extension of time, and therefore it had been accepted that those delays had incurred. And then they'd identified what was the loss associated with those delays, and thereby had dealt with causation. But the court went on, Justice Aikenhead, to provide some guidance on the issue of global claims. And the starting point and the most important point are the following. So for claims advanced by contractors for delay and disruption, they must be proved. You must have factual evidence to prove it, and to prove it on the balance of probabilities that in the first event, certain events for which the employer is culpable occurred, and that these give loss and expense. So let's just give an example. If there is a delay associated with exceptionally adverse weather conditions under a JCT form, there is no entitlement to loss and expense. So if you're claiming part for exceptionally adverse weather, you must show that you're not claiming loss and expense for that, but only for the other events. But if it is for late access, instruction, variations, late information, you need to show that those are events for which the employer is responsible, which quite clearly they are. The next thing is to show that those events actually cause delay and or disruption. And then finally, that delay or disruption caused the loss and expense for which you are seeking. Doesn't seem too difficult. We're going to carry on. However, you must, if you're going to run a global claim, comply with the relevant provisions within the contract. It follows that if you choose to as an employer, you can effectively make it not possible for a contractor to make a global claim. Now, if we look at the NEC, you're not allowed to do global claims because it sets down in very clear detail how you have to assess compensation events. And each and every loss must be put against each and every compensation event. You can't do a global claim under NEC. JCT is quite different. It says you shall issue a notice, and I'm going to deal with the condition precedent on that in a moment. But it says you've got to issue a notice, and then it says you shall provide particulars upon the request of the PQS. But what it doesn't say is you should provide it in this format and this level of information. But there's nothing preventing you, if you're an employer, from doing that. You could effectively ensure that no global claims are put against you by amending the standard terms. But as we've got here, you must have complied with the contract. Now, under NEC, where we're dealing with certain compensation events, the NEC provides that you have to give a notice of compensation event. And it says you have to do it in a period of 8 weeks from when you knew or should have known. And it says if you don't do that, then you have no entitlement. And the question is that right? Can you preclude a contractor from covering such loss and expense? And the answer is, yes, you can. The case, and I'm not going to mention it, but if people want to find it out, let me know. It's a German sounding case. It's quite difficult to pronounce. But what the court said was that a contract can include a condition precedent requirement in relation to loss and expense. Now let's just deal with this issue of condition precedent. What it basically says it means is if you don't issue the notice, you have no entitlement. And you can do that, but you have to meet two requirements. Requirement number one is you have to stipulate when the particular notice has to be issued. And the NEC does that. It says you have to notify within 8 weeks. The second thing it has to do is to state clearly that if you don't issue the notice, you have no entitlement. And the NEC does that as well. So on that basis, it is my view that the NEC can, if you don't follow the provisions for notifications of compensation event, you can lose your entitlement. Now, I need to emphasize one thing in the NEC. The NEC says, though, that this only applies to events where it is the contractor alone who has to issue the notice. So in other words, where it is the obligation upon the employer or under a subcontract, the contractor to issue a notice of compensation event, the failure by the other party to have issued the notice will not preclude their recovery. And the main area where the employer or the contractor has to issue a compensation event notice is in regards to any instruction. Because under the NEC, where you issue an instruction, which is a change to the works information, the contractor, the employer, ought to be issuing 3 notices. They should be issuing the instruction, they should be issuing an early warning notice, and they should also be issuing a compensation event notice. Having issued that, they should then issue a further notice, which is a request for the contractor or the subcontractor to submit a quotation. Now, I only know too well that quite often when instructions are issued by the employer, that's all that's issued. They don't issue a separate compensation event notice, and they definitely don't issue an early warning notice. But in those circumstances, the fact that the contractor does not issue a compensation event notice will not preclude them recovering loss and expense. Let's turn now to JCT. The JCT also has notice requirements, but it says that the contractor shall issue notice as soon as it becomes reasonably apparent. It doesn't go on to say, and this shall be 6 weeks, 3 days, 4 days, or otherwise. It just says as soon as it becomes reasonably apparent. It then has a second requirement to provide further and better particulars. But again, it does not stipulate an exact time period. It is on that basis that under the JCT, the fact that you issue a notice late does not preclude you from recovering loss and expense. I should further add that even if you were never to issue a notice, you could nevertheless claim common law damages which are retained under the JCT formal contract. Okay, we identified the 3 elements that we have to do. There we go. Events occurred which entitle it to loss and expense. Those events caused delay or disruption, and such delay or disruption caused it to incur loss and expense. Question is, what sort of evidence is required? And what the court said is, well, that's up to the contractor. They can provide whatever nature of evidence they like, provided it meets the burden of proof, that on the balance of probabilities, that's the task. It's not beyond reasonable doubt, which happens to apply to things like murder. This is on balance of probabilities. And although this isn't exactly the right definition, basically means you have to prove to 51%. Now, so far as that evidence is concerned, it can be simply witness statements. And quite often when I'm an adjudicator, what the parties put forward to me is loads of witness statements. One party said it happened on Monday, one party says it on Tuesday. I've got to decide which one I give more weight. Lots of factors will come in. Who is the person who's given the evidence? Is it contemporaneous or not? How was it issued? How did the other party respond? You know, photographs are going to be very, very good evidence. But basically, in proving, the contractor can do it in any way they like. Now, when you are faced with a global claim, and I've been faced many times with a global claim, the question the employer says, well, you know, how am I meant to defend this? You know, they've put forward this case. There were delays, and being perfectly honest, they have been granted extensions of time. Yep, they've done that. They've issued notice of loss and expense. They've met the conditions within the contract. They're right there. But the claim, you know, it's £1 million. This is nonsense. It's just not true. You know, and I've spoken with many PQS's employers, and from my experience, when you see a claim, if you want to assess what its true value is, divide it by 4. Others have even told me you divide it by 4 and then divide it by 4. But I've never, ever seen a claim that was actually the right amount. It is always considerably too high. So the question is how do you address that? Now, if you are the employer, what you need to do is to prove that the loss that has been incurred was not caused by you. Now, if you've got a global claim, you can start off by saying, by way of example, well, certain of these losses were incurred because of underpricing in the tender. The contractor would always have incurred this loss. If you look at their tender, they allowed for 1 QS, and here's the breakdown. But if you look, on day 1 of this project, they had 2 QSs on site. So straight away, that loss has been incurred not by any failure of us, but their own problem. And I've noticed they're paying these people during the prolongation period. It's not my problem. There are lots of other things you can look at the tender and say, yeah, certain of these losses would have been incurred in any event. They priced certain elements of works which were always going to be a loss-making event. They had 12 labourers on site because it was so messy. That's not my problem. So what the contractor will have to do as a starting point is to show that had the job gone to plan, they would have made whatever they say is their profit. And they'll have to show that their tender requirements were right. So if you're starting on a global claim, what you should be doing is saying, my tender allowance was this. However, I recognise that if this job had gone to plan, I would have still lost money on my preliminaries. So my true allowance is this, and that's where I'm starting from as my baseline. Because in my experience, I don't think I've ever seen a tender where the preliminaries was right. Indeed, when I was a QS, my director said to me, we only ever allow half a QS because any QS worth their salt will be able to recover their own cost through good quantity surveying. So if you're doing a global claim, starting point must be to show that your tender was properly priced. Equally, if you're the employer seeking to defend a claim, that's the first area that you want to attack. Other areas you will attack quite commonly is for delays that were not your problem. So if there's a global claim, but there are 5 events, 3 events you think are not recoverable loss and expense, for example, exceptionally adverse weather conditions, and if you can prove one of them was the contractor's problem, that claim must be able to be broken down and to remove those amounts. Now, if the global claim is put in such a format that it is not possible to do that, the whole claim fails because you haven't met causation. So you're going to produce a claim, you need to be able to break it down, take out any underpricing in preliminaries, take out anything that are costs caused by your own failure or for events for which you're not entitled to loss and expense, so that you can actually identify that all these costs were caused by all these events. If you can't do that, then the claim will fail. What the court said was that there was no problem that you could claim for a number of events. But they did caveat that, as we're going to identify in a moment. But they said it always depends upon the particular events and the facts in question. But what the court said is they ideally do not want to go down a global claim path, and that a contractor should, where they can, show proper cause and effect and not produce a global claim. They didn't say you couldn't, but they said you ought not to. And where you still go on a global claim, they will look at your claim rather harder. They will look at it with some skepticism. So be aware of that. And as soon as the other party can show that the global claim is wrong, unless you can get rid of that argument, the whole lot goes. It's like a pack of cards, the cards all stacked up on top of each other. You pull off the bottom one, it all goes. If you can show that certain amounts are not recoverable and you can't break down that amount out, it will all go. Important point here, we've got the Society of Construction's delay protocol. And they've identified that there is a risk where you produce global claims that they will fail entirely if it can be shown that certain amounts that you are claiming are not the responsibility of the other party and you can't break it out. Now, as I've said to you, I'm a panel adjudicator and I have seen put before me many global claims. And some of them have been successful, but some of them have failed. And dare I say it, some of them have failed in their entirety. I had no choice. I had to say, I accept that the contractor has in part been delayed. And I accept that that delay would have incurred the contractor in cost. And I accept those costs are recoverable. But a claim as put in the format currently presented, it is not possible for me or the employer to identify what the true loss is, but what is for sure is the amount that is claimed is wrong. And sometimes I've looked at it and said, the claim is just ridiculous. It's a £500,000 project and the claim is £1 million. And I just got no idea why there's £1 million. And what is clear is there was underpricing in the tender, but I don't know what, because there's no information. So, if you're going to produce a global claim, you need to stand back and see how will you be attacked and can you answer those questions? But equally, if you're an employer party, it is those very questions you need to identify and put to the contractor. Where there is an impossibility to disentangle the events, the contractor can nevertheless still claim even if he caused the problem. But the problem is that the contractor has to show that what is being claimed is only that for which the employer is responsible. Now, in the questions that Julie will put, there were a number concerning overheads and profit. And it is one that often creates considerable dispute. You produce your claim for loss and expense, and it comes to £500,000. Okay, that's not bad. We then use Hudson's or Emden's formula, which adds on an extra 20 million. It's fantastic. Oh, that's great. Hey. Question is, can you do it? And the simple answer is, in theory, you can, but there is a caveat. And as Aikenhead pointed out, you have two obligations. The contractor has to prove that in the first event they've incurred a loss by reason of the other party's breach. Now, the argument for overheads and profit is my resources are on site for an extra 6 months. And because of that, I cannot take on another project using those resources. And therefore, I am not going to recover any overhead or profit contribution on that job that I would have obtained. You have caused me to lose this money because originally I was going to do £1 million worth of work in 12 months. What's now happened is I've done £1 million worth of work in 18 months. So 6 months, I've lost an overhead contribution. And if you can prove that's correct, then you can recover loss. But what you have to therefore prove is that but for that job being delayed, I would have secured other work. So what you need to do is twofold. You first of all need to show that during the period of prolongation, you had an opportunity to win work, but chose not to because you felt you could not undertake it. Second of all, you should therefore be able to show that your turnover and your profit during that period also went down. You've now met the requirement. You've shown that but for the delay, you would have incurred something. It's then a question of quantification. And what the courts have said is that you can, if you choose to, use a formula such as Hudson's. But it is this first obligation that most contractors forget about. Now, when dealing with the case that said the formula was applicable, it was a contractor who only ever did one job at a time. It was a small contractor. the person who owned the business was actually on site. So therefore he said, look, I could have done another job, but I didn't because I was on this one. Here's 3 tenders I had an opportunity to price. I chose not to. Here's my emails. I didn't run it. Job went on for 6 months. I was only on this job. Here's my reduction in turnover. Here's my reduction in profit. Here's my formula. Please pay. And the court said, tick box, you've done what you should have done. You've proved causation and you can use a formula to assess your loss. But how many of you have been on jobs that have been prolonged, which has prevented you taking on another project? There is agency staff. You can employ other staff. So unless you can show there are good reasons why you could not take on other works, then you are unlikely to recover overheads and profit based upon Hudson or Emden's formula. Just on Hudson, the fourth point is that, quite often I see CAs, QSs saying, no, prove the loss, you can't use formula. Quite clearly, you can. So far as heads of claim are concerned, I've put down some simple ones here. Prolongation costs, thickening costs, increased costs, loss of overhead and profit. We've dealt with loss and overhead and profit just before, but I want to deal with the issues of prolongation and thickening costs. Now, generally, it is my experience that the delays do not always occur after the job was meant to be completed. What actually happens is that the job starts and the delays occur during the actual contract period. So let's just give an example. Let's just say that we have a project of 50 weeks. It is in those 50 weeks that the delay is incurred, which thereby prolongs us by 10 weeks. The question is where is your loss? Well, the loss actually occurred during the 50 weeks. And it may be in the case that during the 50 weeks, you had 5 men as site agents, but during the prolongation, you only had 3. When should you be claiming? Well, your loss and expense claim should be based upon the period when the delay occurred, so actually during the 50 weeks. What you should actually be doing is identifying when the delay impacted the program, showing the delay period, and then showing what costs were incurred in that period that would not have been incurred but for the delay. Simply putting forward a claim based upon we were complete 6 weeks late, so here's my prolongation cost for 6 weeks wrong, is all too often going to be wrong. Let me give you an example. You are on a construction project and the last 6 weeks, it was your intention to have a finishing foreman. The fact that the job is delayed by 10 weeks and hence the finishing foreman is brought to site after the contract duration and for a period of 6 weeks is not an additional cost. But the fact you claim all the amounts in the period of prolongation, you'd be claiming his cost. It's not an additional, it's not right. Now let's go through another example. Let's say that during the 50-week contract duration, because of delays with lack of information, you've had to retain the scaffolding in site for an extra 2 weeks, and which you dismantle in week 40. But it's been on site for an additional 10 weeks. That is a proper cost to be incurred. It's not during the period of prolongation, it's during the period of the original contract period, but it's still a head of claim you can recover for loss and expense. So do not simply claim prolongation costs. Look at when the delay was caused and claim the losses that are incurred during the period of delay. Now, so far as thickening costs are concerned, these are additional resources. So you can claim them. Because of the delay and all the problems on site, we had to deploy to site an additional site agent and an additional QS. What you'll need to show is that before the delay incurred what you had on site, that this reflected what was in your tender, or if not, was greater than what was in your tender, and explain why. And then explain why more labour, more resources were deployed. What ideally I would like to see is site diaries, explaining what these additional people were doing and thereby providing causation. If you're going to bring on more plant because you've got out of sequence working, again, explain it. Disruption. It's all down to records. What ideally I would like is fully detailed daily returns of what people were doing and why and where. photographs in support, all backed up to relevant instructions or late information, and all the relevant backup and support. So far as increased costs are concerned, you will have included within your tender or deemed to have included for certain increased costs. To give you an example, you've tendered today and have won the job and you're starting today, but you're not going to do certain element of works until a year's time. In a year's time, when you procure those materials, it is likely that they have gone up in price. You've got no entitlement to recover that extra price. But what is actually happening is you are procuring those materials 3 months later than that. So what you should do is to work out what your increased cost would have been if you did it in December. And then what the additional cost is that you're doing it 3 months thereafter. The whole point is to properly support your case. And all too often, it's my experience that contractors fail to do that. Now, I have no problem with that. You know, it is quite common for contractor to produce a claim and then through a process of negotiation to reach a compromise with the employer stroke the PQS. However, if you don't, and you therefore decide either you need to go to adjudication or arbitration, you're a brave man if you go on the basis of a global claim. I think it is all too often possible to produce a claim that is not global. Now, I have never met a client who has every possible record available. They always have problems. It's always the job that goes wrong that they have the worst records on. It's always the job that goes wrong that labour and resources leave. I often said a joke, when I go down to sites to speak to the staff when instructed to produce a claim for extension and loss and expense, what does the person on site always say to me when I ask them questions? And the answer is they always say, I don't know, mate. I only joined yesterday. Everybody else has left. So it's a question of what the records are. But by delving into it and breaking it down, it is possible to produce a claim that is not globalized. And what you need to do is to start off with the tender and to basically put all the tender resources costed against the original program. So you're going to say, if the job had gone to plan as per our program, this is what resources would have been expended. What then you do is you effectively overlay that program with the as-built program and with the as-built resources expended. You then take one from another, and then you allocate those resources in the windows to the delay events that cause the period of prolongation. Now, I know that's a very simple way of explaining it, but it is possible to do. And that is what I strongly urge you should be doing. If you are an employer faced with a claim, what you should be doing where it's global is to show why it is wrong. Look at the tender resources, look at what has been the delays, and to show that there are other events that could have caused the loss. Look at what was recovered in the variation account and has that been omitted. What you're looking to do is to prove that the claim as advanced is wrong and that you cannot show what the true loss is. Okay, I've covered a lot there. Any questions, Julie?
Yes, there is. And we've had some additional questions. We'll start with those.
Struggling to hear you, Julie.
Oh, can you hear me?
Yeah, I can hear you there, but not when you're facing the other direction.
Okay. Is the contractor's position significantly weakened if its notice of delay is issued some 2 years post original completion date, whilst still on site with minimal early warning notices having been issued? The contractor is therefore having to rely on client progress reports and meeting minutes to substantiate the factual records of delay in building its delay analysis.
Right, well, the first issue is that everything goes to weight. So if something is issued at the time, it may have more weight. But the fact that it is issued sometime later doesn't mean it's wrong. All we've got to meet is the balance of probability. So it's a higher hurdle to leap, but it doesn't mean you can't. So yes, you can produce the claim much later on, and it may be you get exactly the same amount because the claim is produced after the job is finished. My experience, most loss expense claims are produced after the job is finished. Ideally I would wanted them at the, during the job, but the fact it's not done until afterwards doesn't necessarily hinder it, provided you can evidence what you are claiming. There is a couple of caveats. Obviously, as we've mentioned under the NEC, there are certain notifications requirements that are needed to be put in. You need to meet those conditions. But provided you meet the conditions of the contract to be able to recover loss and expense, the fact that you produce it a much later does not preclude your entitlement. It just means that there may be less weight given to your evidence.
Okay. Someone else is asking, to what extent has a contractor to prove he has mitigated any losses?
Okay, we have in the contract things like the contractor shall use their reasonable endeavours, or the contractor shall use their best endeavours. The best explanation I can give is to say that the contractor should not be expending further money. Now, there's often this argument of constructive acceleration. And constructive acceleration is an argument that says along these lines, you didn't award me an extension of time. I've therefore had to complete as per the original contract completion date. And as a consequence of that, I've had to work weekends and evenings, and I therefore want payment for it. It is very rare you will win an argument of constructive acceleration. But it's equally the case, therefore, that if you are a contractor where you are being delayed, you do not have to suddenly work weekends and evenings. What you need to do is to do what a reasonable contractor should have done. So you should not be spending more money, because if you are, you're effectively putting the employer to more cost, which maybe they don't want to have. So you shouldn't be spending more money, but what you should be doing is trying to mitigate it, which is, for example, looking at your sequencing, looking at your resources, what you've deployed on site, are they reasonable? But it isn't a particular onerous task to meet. What you're going to do in very simple terms is to say, what would another reasonable contractor have done in these circumstances? It is my experience that employers believe there is a far greater onus upon the contractor, but there is not.
Okay. Someone else is asking, overheads. How do you prove in practice what evidence that you would have secured other work?
Well, it's very simple. Is ideally you want 6 invitations to tender that have been issued to you, and 6 emails in return saying, sorry, we can't tender because we've got this other work on. Now, the reality is that most contractors won't do that, because if they refuse to tender, they will maybe not get those opportunities or further opportunities in the past. So most contractors do tender, but what they do is they overprice the works. Indeed, I'm aware that certain contractors seek a cover price. So what they'll do is they'll get the price for maybe some of the other competitors and add on 20%. Where I've been involved with contractors, I believe and understand that, in the past that may have been done. And I'm even aware in some circumstances they nevertheless won it. But what you would need to show in those where you have tendered is you priced it so high, it can be shown that you would not have won it. So number one is to show that you would have secured more work, but for the delay. And then number two is to show that your turnover and profit as a consequence went down in that period.
Okay. Evidence of actual costs to be provided by the contractor. As an employer, when I request payslips to prove actual cost of manpower, the contractor always refuses. Any suggestions on what to do?
Yes, what is generally done is it's all to do with, or now it is data protection and things of that nature. If you are convinced that the values that are being put are so unreasonable, what you should say is that I'm quite happy to come to your offices to look at certain pay slips and not take them away. Contractors must keep that level of information and ought to be able to supply it. But if you also think that what's being put forward doesn't seem unreasonable, then I question whether it is necessary. But I have, when I'm involved in adjudications where parties are looking to prove the costs, I'm going to look at them and say, does that look reasonable? Carpenter, £150 an hour. I've got a feeling that's a bit high.
Okay. What does prospective mean in terms of analysing an extension of time?
Prospective. I don't know in what context that means. I can imagine that maybe they're looking under a JCT, and that where a contractor submits an extension of time notice from sufficient particulars, the architect, employer's agent, has 12 weeks in which to consider it. And it may be, therefore, not clear what the actual delay will be incurred. And therefore, they've still nevertheless got to assess what that delay is. I'm guessing that's what they're referring to. I'm not quite sure. If that individual would like to email me in what context, then I'll hopefully advise them more fully.
No problem. Someone else, which is a pre-asked question, is asking, on a current project, extension of time number 1 was valued by means of prolongation, and the OH&P element was dealt with by the Hudson's formula. This was agreed by all parties, being the PQS, contractor QS, and the client. However, now that there were further extensions of time pending, the question is, can extensions of time number 2 and indeed subsequent extensions of time be valued in the same way, using Hudson's, as this precedence has been set under the first extension?
The answer to that is that in view the first award Hudson's has been used, the employer has thereby accepted that the evidence that has been provided that they've turned away work has been met. The issue of causation has been met. It's therefore to some degree difficult for the employer to say that having met it in regards to the first delay, it should not apply under the second delay. So there is some support, some strength to the argument that it should be used in the future. However, if the amount has actually been agreed, they can't open up the further rule, but they can say and try to argue that we were trying to be helpful in the past, but now the job's gone further on, we don't think that you have actually turned away for this further period and you need to prove it. It's then a question of balance of probabilities and whether an adjudicator, arbitrator, the court decide that what was provided previously was sufficient. Some adjudicators will say, you've met the first period, you've paid overheads and profit. It's very difficult for me not to agree that it should equally apply to the second and third awards. But I think there is an argument that could potentially be run saying, well, it's a different period, it's a different delay, and what was agreed previously wasn't sufficient. We were just trying to be helpful.
Okay. Another comment here. Under NEC, people's overheads percentages are sometimes very high. What is the average percentage? This person is currently experiencing a 45% charge.
The answer to that is I don't know, because I only see those that end up in dispute, and that's a fairly small proportion. From those that I've seen, I've seen a few, 45 does seem fairly high. I have seen generally about 25.
Right. Okay. Is a contractor only entitled to time and not money if awarded a relevant event and not a relevant matter?
Okay, we're talking about JCT. JCT has relevant events and relevant matters. This is a difficult question because the provisions for extension of time and loss and expense are not related. They're two separate provisions. Unlike the NEC where we have compensation events, under JCT we have relevant events and relevant matters. Now, it may be the case that you've got no entitlement to extension of time, but you've still got entitlement to loss and expense. No doubt a number of people are certainly sitting up. Give you this example. We have two critical paths. We have a critical path through the internal works, and we have a path that goes through the external works, but which is not critical. The external works includes an amount of pointing to an existing building. And the pointing to the existing building is a provisional quantity of 100 square meters. The employer, the contractor, erects the scaffold, looks at the pointing, gets the instruction, and has to do thousands and thousands of meters of it. We've now got a variation which requires the scaffold to be retained on site for a lot longer period. It's got nothing to do with the job being prolonged, but it's going to be on the site for a lot longer period. There's been a relevant matter. There's been a delay by late instructions, but there is no entitlement to extension time because the job is not being prolonged. You can still recover the loss and expense associated with the scaffolding. We've then got a situation that at the end of the job, it rains. There is exceptionally adverse weather conditions, and the contractor is awarded 3 weeks extension of time for exceptionally adverse weather conditions, which does not entitle him to recover loss and expense. It's not a relevant matter. But he can still claim for the scaffolding that was on site because of the pointing. It's still recovery. So the point is that whether you're granted an extension of time or not is irrelevant to your recovery of loss and expense. They are different clauses. And provided you can prove there was a relevant matter, you can recover loss and expense. It is obviously better to get the correct relevant event because it supports the relevant matter. It has been decided that you're entitled to 3 weeks because of instructions, which is a relevant event. To some degree, you now have proved that equally there is a relevant matter for the same item. But it will, for those of you who are in, been on projects, it is not unusual that where the job is delayed and there's been late information, that the employer decides to issue an extension of time for exceptionally adverse weather conditions. Quite often the award for extension of time doesn't actually match the true delay. And then contractors start to get concerned, I won't be able to recover loss and expense. Well, you can, because it's irrelevant. You need to prove what your loss was and why.
Someone else here is asking, under JCT DNB, can a contractor claim loss and expense for, say, UKPN or Thames Water closing the road outside the site which affected the site deliveries?
Right. As far as recovery is concerned, it all depends upon the contract and what is the relevant event, relevant matter. Now, if there's been a close outside of the site, unless it's caused by the employer, it's unlikely to be a relevant event. It's going to be an event for which the employer was not at fault. So under JCT, we have provisions for extension of time for weather. That's not the employer's fault, but we have them. We have provisions for extensions of time for statutory authorities. It's not the employer's fault, but you have them. We have them for force majeure. Again, not the employer's fault. But then because they're not the employer's fault, the contract doesn't provide for loss and expense for these events. Now, if there has been a close outside of the site, and it may be because it's because of a statutory undertaker undertaking works in laying pipes or otherwise, that's not an event which is a relevant event because it's got nothing to do with the employer, but it would fall under delays for statutory undertakers, but you would not be able to recover loss and expense.
Okay. Under NEC, and I think this will be the last question for today, under NEC, if you're assessing an extension of time 2 years after the event at the end of the project, how should you analyse the impact of the event that caused the extension of time?
Okay, NEC, in my view, is one of the most difficult contracts to follow with the assessment of extensions of time. Under the NEC, a delay to the completion date is assessed as the difference between the date stated on the current accepted programme and the last. So what we should have is that we have an accepted programme produced today and which shows us on time. A week later, there is an event that occurs which causes delay and is a compensation event. In theory, what should be issued is another programme for acceptance. The revised programme shows a week's delay, and therefore we simply compare this programme to the last, the difference is a week. Now, just to emphasise this, let's say the programme that was issued last week showed us finishing a week early, and the programme we issue now with the new event shows us finishing on time. The contractor would nevertheless get an extension of time of 1 week, being the difference between the last accepted programme and the current. So that is how it is meant to be done. So the situation that's being advised at the moment should not happen, but it does. And what we've got a situation is not uncommonly, is that although the contract provides for the issue of accepted programs every month, when the employer instructs and they know the current program is no longer efficient, when the contractor chooses to, and with each and every compensation event where it's deemed that the works will be delayed, quite often this doesn't happen. So there are no programs and there is no accepted program. So we have a problem. The contract says your assessment is based upon the last accepted program and the current accepted program, but there isn't one. What therefore is going to happen is retrospective delay analysis. So someone's going to have to produce a retrospective delay analysis, and the way it ought to be done is on the basis of a time impacted program. What they should be doing is putting themselves back in the position they would have been at the date that they say the event occurred. So they will start on day one and say, on day one, this is what would have happened. We would have finished on time. We now look at week one and look back on that day and work out what we think was the problem on that day, particular event, and what we think the knock-on effect would have been or was, because we're now looking at retrospective. We then go to the next event. The next event happened 2 weeks later. We're going to produce another program as if that date. We're going to update all the progress reports to reflect that date and then show what the knock-on date is. And that's the delay caused by the next event, and so on and so forth. If you're an employer, what you need to do is to look at those programs and undermine them and show that the event that they show as being critical was not critical. And it's all going to go down to what is called the time now line, which is used in that program and what is shown as the driving or critical activities. Now, one thing that is almost certainly going to come up is concurrent delay. And there are many arguments about what is and is not a concurrent delay. And there is, in fact, a considerable difference between the way the courts consider this in Scotland when compared to in England. In Scotland, the view is generally that you can apportion delay. Whereas in England, the view is that if there is a delay, two being concurrent, one for the employer and one for the contractor is nevertheless entitled to an extension of time. But if you look at the draft Society of Construction Law's protocol on delay, they identify quite rightly the difference between concurrent delay and concurrent effects. A concurrent delay is a delay that happens on the same day. So today, I'm given an instruction for additional works. That's a delay caused by the employer. Today, I've got no carpenters on site, so not only cannot they not do the work that I wanted them to do, they can't do this instruction. That's an contractor's delay. But ignoring all of that, there is a hurricane going through the site today, and which prevents any work being done. So we've got 3 delays all happening today, which are concurrent. One being the employers, one being the contractors, and one being a neutral event. Under English law, the contractor would be entitled to a full extension of time, but may not be able to recover loss and expense. However, that is not what generally happens. What generally happens is, yesterday the carpenters weren't on site, today the information was issued, and tomorrow is the situation with the hurricane. They are not now concurrent delays, it is their effects that are running concurrently. And the general rule that will apply in the UK effectively is that they will look at the first delay and it will be the delay that happened yesterday. And you would say, as of yesterday, there was going to be 6 weeks delay. The next event then will impact the program after that delay occurs. Now, this is a case called Balfour Beta Jest amount. It's called between the gross assessment and the net assessment. And what basically happened was that the contract was meant to be completed today. But today, the works are going to be completed 1 week late. And it's the contractor's fault. Not entitled to any extension time, it's their fault. So they're going to finish in a week's time, 6 days elapse, and then the employer issues an instruction for 2 days' work. Question is what is the contractor entitled to as an extension of time? Contractor said, well, I'm entitled to 7 days, but for the instruction you've just given me, I would have finished, and I can't now, so I'm therefore entitled to 7 days being the original completion date to when I finish these works. That is the gross assessment. The employer said, no, that can't be right. You would have finished in any event 6 days late, but because of the event I've caused, I've only knocked you on by a further day. You're only entitled to 1 day. And the court said the employer was right and they could only get 1 day. And the reason for that, as we can see, is that the contractor's delay occurred first. And at the day that impacted, they would have finished a week late. You then look at when the next event impacted the program, which was the instruction, and that knocks it on by a further day.
Okay, I know that was the last question. There's just one point of clarity here on something you were mentioning earlier about the weather. Someone's saying in a recent subcontract, there was no reference to the effects of weather, inclement or otherwise. The main contractor tried to reduce the delay period by a period in which there was bad weather. And the person concerned took the answer or took the position that there was no contractual provision. This was a main contractor risk item, and he could not reduce the period of delay claimed. Was he correct?
Could you say that? Sorry, I didn't catch all of that. Could you say it again?
Sorry. In this person's recent subcontract, there was no reference to the effects of weather, inclement or otherwise. The main contractor tried to reduce the delay period by a period in which there was bad weather, and the person who's writing said they took the position that as there was no contractual provision, this was a main contractor risk item and he could not reduce the period of delay claimed. Was he correct?
I don't quite understand the question. I am guessing that what they're saying is that the contract finished 10 weeks late. They claimed 10 weeks extensions of time, and the contractor said you can't claim 10 weeks because 1 week of the delay was caused by exceptionally adverse weather conditions, and therefore you can't claim that. And the subcontractor said, no, you don't have an event. The contractor's right. If he can show that the 10 weeks delay, 1 week of it was caused by exceptionally adverse weather conditions, then the subcontractor's got no claim for that week. The only thing they could be doing is they could be trying to argue along this lines, is that subcontractor says, look, you've given me all these instructions and I can show that it delayed me by 10 weeks. The contractor says, well, I accept that these events caused you by 10 weeks, but that was over a period of exceptionally adverse weather conditions, and therefore we should deduct that. And I think that would be wrong, because it is not the exceptionally adverse weather conditions that has caused the delay, it is the instruction. And it is taking them across exceptionally adverse weather conditions. That's the contractor's failure. It would equally apply if it took them across Christmas. So depending upon the nature of the question, there's the two alternative answers.
Okay. Right, thank you. That is all we have time for today. So just remain to say thank you very much for your time and expertise as always. And thank you to everyone for attending. Our next seminar is tomorrow evening, where Mohammed Haq is presenting the latest in his adjudication matters series. Tomorrow night he's talking about drafting a claim or response. That's at 6 o'clock. If you would like a place, please email seminars@silverllp.com. Otherwise, we have two next Wednesday, Design Negligence and Duty to Warn, and Richard is back with the latest in his Construction Essential series, going into further detail on extensions of time. Again, if you'd like a place on either of those, seminars@silverllp.com. And if you wish to contact Richard directly with anything that he's discussed today, richardsilver@silverllp.com. So thank you very much all, and I hope everyone has a good day. Thank you very much, Richard.
Thank you all.